All rise. The Honorable the Chief Justice and the Associate Justices of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before the Honorable the Supreme Court of the United States are admonished to draw near and give their attention, for the Court is now sitting. God save the United States and this Honorable Court.
Be seated, please. Petitioner ready to proceed?
Yes, Your Honor. Petitioner is ready.
Please do so.
Chief Justice, and may it please the Court. My name is Victoria Porter, and I represent the Petitioner of the United States in today's argument. Your Honor, I would like to request 2 minutes for rebuttal before I begin. Your Honors, the issue in today's case is whether the search of the respondent's car was a legal search incident to arrest exception to the Fourth Amendment's warrant requirement, in light of the fact that at the time of the search, the respondent had his hands handcuffed and was seated in the back seat of a police car. Now, the Belton rule applies to the search of the respondent's car and makes it a legal search incident to arrest for 3 reasons. First, the search of the respondent's car was limited in scope and it was made contemporaneous to its lawful custodial arrest. Second, the Belton rule makes a search of an automobile following the lawful custodial arrest of its occupant categorically reasonable. Thirdly, policy reasons support applying a bright-line rule over a case-by-case approach in order to provide a workable definition of the scope of the search for police officers in the field and in order for them to protect their safety.
But Belton doesn't, I mean, it turns on the risk to the officers.
Yes, Your Honor, it does.
So what was the risk to the officers in this case?
Well, Your Honor, in Belton, the court said categorically that the interior compartment of the automobile is the scope over which the arrestee has possession and control at the time of his arrest. And the area over which he has possession and control was decided in Schimmel to be the area over which he could potentially grab a weapon, potentially produce evidence and destroy that
Right, and I
evidence.
agree with you, but in this case, Mr. Autry is handcuffed in the back of a police cruiser. So you had officers outside of the police cruiser and you had his car. What was the risk to officer safety?
Well, Your Honor, the Belton rule doesn't necessarily hinge on the actual and present risk to the officer's safety at the time of the search. More likely, it hinges on the presence and the risk of officer safety at the time of the arrest.
I mean, if Mr. Autry somehow got out of his cuffs and bolted from that car, do you think there's police officers standing around and sit there and let him go to his car?
No, Your Honor, but we're arguing that the bright-line rule approach advocated in Belton will apply to a myriad of fact patterns. And unlike the fact pattern in Belton, when there was a very obvious and imminent threat to the officer's safety while conducting the search, the fact
What about
pattern...
the Mincy case? Doesn't the Mincy case indicate that the officer safety or the exigency portion of the rule, if there is indeed an exigency portion of the rule, applies at the time of the search, not at the time of the arrest?
Correct. And at the time, the problem, again, in analyzing the Mincy in opposed to this case, is that in Mincy there was an overly expansive time frame that the search was involved in. In this case, the time of the search was limited to be contemporaneous to the arrest of the individual in question.
Well, I mean, it did go on for a long time, but the point was, at the time where the search was challenged, there was no longer any threat to the safety of the officer. Well, at the time this search was conducted, isn't it true that there was no longer any threat to the safety of the officer?
That is true, Your Honor. However, again, we believe that Mincy is distinguishable because the contemporaneous requirement in the Belton rule hinges on a closer nexus of both a spatial and a temporal frame from which the arrestee must be to the time of the arrest.
The Court of Appeals applied the Belton test. They did so using a Schimmel analysis, and they ruled that this fell on the opposite side of the Belton bright line from your point, from your perspective. What did the Court of Appeals do wrong? What was in error about the Court of Appeals opinion?
Well, the 12th Circuit relied on a very narrow reading of the Belton rule. The 12th Circuit held that in order to apply the Belton rule, the Schimmel prongs needed to be in existence prior to the application. We urged the Court that the Belton rule, while it didn't overrule the Schimmel prongs in any way whatsoever, it merely said that there is a different fact pattern involved when the arrestee is an occupant of a car. for numerous reasons, one being that a car is a different situation than an arrest that occurs inside a home. Arrest cannot physically occur inside a car. However, once the arrestee is removed from the car, the exigencies present and the dangers lurking inside that car still exist once he's been removed from the car and arrested.
Was the Court of Appeals correct or incorrect in applying a Chemmel analysis to decide which side of the bright line this case falls on?
The Court of Appeals was incorrect. We believe that the Belton rule inherently from the inside out applies its own exigency analysis.
So Belton operates and stands independent of Chemmel?
It does, Your Honor. We believe that the Belton rule, while not in conflict with Chemmel, does not necessarily rely on the justifications that were present in the Chemmel search in order to enact the rule and to uphold that a search is legal.
Do you believe the Belton court was trying to establish a new rule without reference back to the factors that were considered important in Chemmel? Do you really believe that?
It wasn't entirely dividing itself from Chemmel, but the Belton holding did rely a lot on the holding in the United States against Robinson, where this court held that the fact of a lawful custodial arrest, inherent in that fact pattern, there are exigencies that exist. And we're going to say that they exist in every lawful custodial arrest. And as a result, in the United States against Robinson, the court held that you may search the person of the arrestee. Similarly, the Belton rule applies its own analysis of the exigencies present in every
Well, you
arrest
appear to be
situation.
conceding that the Belton rule does require an exigency element.
Yes, Your Honor. We concede that. And we believe that the Belton rule from inside out limits its application to the points where those exigencies exist. In Belton, the court was saying inherent in every arrest situation where the arrestee just got out of a vehicle or was in a vehicle when he was arrested, there are going to be significant dangers in that situation. And as a rule, we're going to say that those situations allow the officers to define the scope of that search as the interior compartment of the car and the car itself.
Do you think Belton should be expanded to include the trunk?
No, Your Honor, we're not arguing for that today, and we do not believe it should be expanded.
So you would agree that if the officers wanted to search the trunk, they would have to get a warrant?
Yes, Your Honor, we would agree with that. Despite the court's holding in Michigan against Long, in which the court upheld a Terry analysis as applied to the search of a car, we believe that the Belton rule would not extend to the trunk area of the car.
Why couldn't the officers have gotten a warrant here? There was no one in the car. They had enough people present to secure the scene. Why couldn't they simply have gone and made an application and had a magistrate issue a warrant for the interior of the vehicle?
Well, Your Honor, it's unclear whether the officers believed they had probable cause on the scene to search the car.
So now they can search without probable cause as long as someone is arrested within 8 or 10 feet of the vehicle.
Well, with the Belton rule, what we're saying is that the government's interest outweighs that individual's privacy interests, and the exigencies of that arrest situation should allow officers to limit the dangers lurking in the car, should act in their own safety to prevent the destruction of evidence, to prevent dangerous things from existing inside the car, perhaps turning on them while they conduct their searches.
But those very dangers that you're talking about could be present in the trunk. And so I'm having trouble seeing that if there's not probable cause for the issuance of a warrant for the search of the trunk, or in response to my colleague's question, there's not probable cause to go get a warrant to search the interior of the car. I mean, what's the basis then for allowing, it seems like a trampling on the Fourth Amendment then? So even though there's not probable cause, have at it. Go search the interior of the car, even when the defendant's sitting in the back of the police cruiser.
Well, Your Honor, the Belton rule limits the scope of the search to the area over which the arrestee had possession and control at the time or immediately prior to his arrest. And the Belton rule defined that area only as the interior of the car. And in doing so, the Belton rule limited the scope of its search in order to provide a safety for that individual and for that individual's privacy interests in his trunk. Your Honor, we believe that the policy reasons supporting a bright line rule application would do two things in this case. First, it prevents police abuse of discretion in the field. Secondly, it protects officer safety. Now, a bright line rule approach is more apt than a case-by-case analysis in these sorts of situations where arrests of recent occupants of cars are conducted for several reasons. Between 1997 and 2007 alone, 1/5 of all officers feloniously killed in the line of duty were killed while conducting custodial arrests. It's a dangerous situation, and if officers can walk into that situation knowing where they can search, where they can't search, and what are their limits, their safety can be enabled.
Wouldn't we be better off having a rule that permitted the officers to make a search and engage in self-protection in circumstances where the suspect was not under arrest? Would that be a better place to draw the right line?
Well, no, Your Honor. And going back to the court's holding in the United States against Robinson, that the exigencies present in that arrest situation in part justify the application of the Belton rule in order and also justify the officers acting to preserve their safety.
Well, I mean, Justice Scalia would have us adopt Robinson and apply it more broadly to include automobile searches, but he was critical in the same paragraph of the Belton rule. So wouldn't Robinson be a better approach? Shouldn't we just scrap Belton and extend Robinson? Would that make it a lot easier as a policy matter for folks to understand what the law is?
Well, Your Honor, if we do adopt Scalia's approach, as I believe you're referring to in the United States against Thornton, where he wanted to have some sort of a justification more so in place, you lean towards a case-by-case approach. And in doing so, a case-by-case approach undermines the very fact of having a bright line Belton
He says
together.
anytime you make an arrest, if it's adjacent to a vehicle, you can search the vehicle.
Well, Your Honor, the Belton rule...
Case per case about that.
Well, Your Honor, in the Belton rule, the case-by-case approach is
I'm
specifically...
talking about Robinson. If you extended Robinson, what would be case by case about that? It would seem to be pretty clear.
Well, if you did extend Robinson to situations, you would also have the problem of where do you draw the line. And this is the positives about the Belton rule, is that the line is clearly drawn for police officers. If we did extend the rule and perhaps mitigate Belton in the way that Scalia wanted to, we have a problem of, do you draw the line at 8 feet from the arrestee's location? Do you draw the line at 10 feet from the arrestee's location? And if you do, will that require the officer to make an analysis in the field and perhaps put an undue burden on his
That
judgment?
would be easier than weighing exigent circumstances each and every time an arrest is present.
That would indeed, and that is exactly what the Belton rule eschews, in the very weighing of exigent circumstances in every time an arrest is conducted. And for that reason, the Belton rule is a positive thing and will give officers a bright line and a way to approach each arrest situation and know where and when they can search.
But there's still some line that has to be drawn. I mean, if your client had been arrested, or I'm sorry, if the respondent had been arrested and taken to the police station, the police can't go then search the car or go bring the car down to the station and search it. So, I mean, there's a line, that's clearly on the other side of the line.
Correct, Your Honor. And we believe the Belton rule in its contemporaneous requirement does in fact draw that line easily. The court has said that a search is contemporaneous if it's not remote in time nor place from the arrest. Now this has both a temporal and a spatial delimit. The arrestee must be at the place of the arrest and the car must still be at the place of the arrest. The Belton rule makes this clear that that applied in Belton and is an easily applied and workable definition. Therefore, from the Belton rule itself and the contemporaneous requirement in the Belton rule, there's an easily seen line that officers may judge and decide where they can and cannot search. Your Honor, I see that my time is over. May I make a brief conclusion statement?
All right, you may make a brief statement.
Your Honor, we believe that the Belton rule should be affirmed and clarified by today's ruling, that the 12th Circuit should be overturned. The search of the respondent's car was a legal search incident to arrest. Thank you.
Thank you. I didn't win it. I came in second. But when I competed, there weren't nearly as many competitors. I can tell you that. We did, because you had 69 competitors. We didn't have 69 people in my whole class. So there was not nearly as much competition. But nonetheless, I was proud then, and I'm still proud, to have come in second in this competition. And I know that Judge Johnson feels the same way about having come in first. But what's important is that you went through this and you got excellent training, and all of you who reached the finals have accomplished quite a bit to have gotten to this point. And I hope that you feel proud of having done so. I can tell you, like I say, I still do, even though I didn't win the ultimate prize, but I was proud of getting as far as I did. So at this point, I'm going to announce the outcome in the opinion of the judge. We thought the runner-up was Andrew Finnegan. And it was our judgment that the winner was Victoria Cora.